morning, ladies and gentlemen. This is the first traffic two-day seminar I've done in California. Probably the last, you know what I mean? So you people are very lucky to be able to attend this one. I usually do these out of state. And my name is Richard McDonald, and I'm a California citizen. I'm not a citizen of the United States, and I'm not a U.S. citizen as defined under the 14th Amendment. With all the legal rigmarole taken care of, now I can proceed. So lay the foundations, lay the guidelines. What we're going to do in this two-day seminar is basically to teach you how to take the rocks out of your wheelbarrow and put it in the government's wheelbarrow. You don't push a loaded wheelbarrow uphill. What you do, you push an empty wheelbarrow uphill, and you put all the rocks in the government's wheelbarrow, then you overload it on one side so it tilts over. So they collapse. They can't do anything if you know how to do the arguments. And that's what primarily what this is concerned about, is to teach you court procedures, letter writing to the IRS, letter writing to the FTB, letter writing to the DMV, letter writing to the code enforcement, letter writing to the Better Business Bureau, whatever you want to do. These principles remain the same. I don't care whether it's a major case or a minor case. The principles are identical all the way through the line. So once you understand the principles, which I'm going to be teaching for 2 days, you'll have a good foundation to move forward on any type of letters you're going to write. Now, turn over to the page there where it says Court Procedures at the top of the page, just past the end of the Patriots. Because that's where we're going to start, because we've got a lot to cover and I have to talk a lot. So pay attention. The following procedures can be followed so that you can enter all the required briefs and motions in the court. Remember that all briefs and motions must have an affidavit or declaration attached to it. All papers should be filed minimum of 10 to 15 days prior to court. It's very important. If you're filing judicial notices on a judge trial or a motion in limine with a jury trial, they have to file 10 to 15 days in advance. That gives the opposition a chance to start, okay? Okay. Butch is okay, the boy is free. Okay. You can only file one demur in every case. And demur basically says, so what? The demur challenges the sufficiency of the complaint. And there's several different demurs you can use. Some people don't like to use them. But demurs can be good if you know how to do it. But you have to know the arguments. And that's what I'm about to try to teach you, some of the arguments that to be used in these. Okay? You can file a notice to abate based on non-assumpsit. There's a whole bunch of different briefs that you can file. You can file as many as 30 different motions to dismiss, each one based upon a separate issue. You don't put all your eggs in one basket, because if one egg is bad, the whole basket's bad. So you file a separate one for each and every thing. One motion to dismiss because you're not a person. Motion to dismiss because you don't have a motor vehicle. Motion to dismiss for whatever reason. Motion to dismiss because the cop had 4 eyes, you know what I mean, or whatever, you know what I mean? It makes no difference. But everyone must be separate, and you must attach an affidavit to that motion. It's very, very crucial. And you always file an affidavit of citizenship with the court. The reason being, because once the court accepts that, that's prima facie evidence in any other previous subsequent court case you have, if you file an affidavit of citizenship. Because once the judge recognizes that your affidavit is truthful, you follow me? Now you're a state citizen. Now, if any subsequent case, you can always bring up that affidavit that you filed in the previous court case, because the court recognized that. And judicial notices, we found out, are more important than anything else. You can file as many as 65. I had one person in Denver, Colorado, file 65 motions in limine in a federal court case. Which would be judicial notice. She had a jury trial there. And the judge accepted them all. Because they understand, if you understand. If you don't understand, they're going to sink you right off the bat. It's no problem. And when you do your judicial notices, you do one for every subject matter, one for each court case. I don't care if you've got 30 court cases, do 30 judicial notices on that. We're going to go through several of them as we go along here. See, and after you file your papers, then you have to understand what the judicial notices are and understand the court case, and you have to argue it. Some judges will say, okay, I accept them, I accept them, I accept them. Other judges say, I'm going to deny this. First thing out of your mouth, Your Honor, why are you denying my judicial notices? Crucial to my defense. In other words, are you telling me, don't be afraid of the judge. As long as you stay within those guidelines, you have to say, Your Honor, is this court telling me that I'm going to be denied due process based on the fact you're going to deny these judicial notices? He'll say, no, I'm not saying that, but by denying me this judicial notice, you are, in fact, denying me due process. You're limiting my defense. Is this what you're going to do, try to limit my defense? And that's limiting a defense. Write that down. That's a no-no in every court in this nation. They cannot limit your defense. And you'll be getting court cites on the next little paragraph. Remember, the judge cannot use his personal knowledge of the law or feelings while ruling from the bench. He can only rule on the evidence before him. Explain to this by saying, Your Honor, the court cannot use its personal knowledge or feelings in rendering a decision, but must rule on the evidence submitted. And you give him a judicial notice to that effect. And got a Ninth Circuit Court of Appeals court case that says judge can't use his personal knowledge. So, in a DMV case, you have to bring in if they say you in a DMV case when you're before the court on a DMV case, the first thing they got to bring in is the statute that created the DMV and authorizing them to see if they don't bring in the foundational arguments and you step off on the number 2 or 3 argument, you've already admitted they exist. It's the same way with the IRS. There's no statute creating the IRS. But if you address Title 26, you admitted the IRS exists. You've lost your foundational argument. You never, under any circumstances, lose your foundational argument. I don't care whether it's DMV or what other agency. You always, consistently, stay with your foundational arguments. And make them prove every single aspect of the case. They got to prove you have a motor vehicle. It's impossible. They have to prove you're a person. It's impossible. They have to prove you're driving. That's impossible. Everything is impossible. Then they have to get the DMV record in. And it's very important that they do not enter the DMV record into evidence. And there's many different ways of stopping it. We've learned how. We're very successful most times if the guy knows how to do the argument. Because without proof that you did or did not have a driver's license, there can be no conviction. Without proof from the DMV that your vehicle, your automobile was registered or not registered, there's no conviction. They have to have that DMV record entered in to create the corpus. And without that, you have to stop them. And we're going to be going into them. And when the officer gets up on the stand, he's going to say, I saw the defendant driving. Objection, Your Honor, right away. No foundation. Assumes facts not in evidence. Write that down. Objection. No foundation. Assumes facts not in evidence. It's very, very important. Because if you don't lay a foundation at the trial level, the upper court will not hear the issue. You have to lay all the eggs out at the trial level. You have to be consistent. I don't care if you have to object to every other word he says. If he says, I saw the defendant driving a motor vehicle, objection, to, Your Honor, objection to the word driving assumes facts not in evidence, and I also object to the word motor vehicle assumes facts not in evidence. Go right on to strike every word he's got. And you can put a judicial notice that the motor vehicle means commercial in nature, and the judge will accept it. And always put the burden on them. Ask where the evidence is. Do you have any evidence whatsoever to submit to this court that I am a person? Do you have any admissible evidence in this, that I have a motor vehicle, as defined by the courts as it relates to the motor vehicle code? Do you have any admissible evidence? They don't. Then they're going to wind up with nothing. And over on the next page it says how to enter evidence into court. How I enter evidence into court works very successful. What you do is you have your ID card, which we always carry, I think. You have your ID card. It says, officer, at this time you stopped me, you asked me for ID, and I presented you with this, did I not? He'll say, yes, one similar to that. This is the same card, I only have one of these. But is this a card? Yes, it is. Your Honor, the officer admitted that this is the card. I'd like to enter this card into evidence. And you go over and give it to the prosecution, show it to the judge, then give it to the clerk, and she enters it into evidence. Now you've established that is evidence. That's the way you enter evidence in. You want to do your affidavit the same way. You can do an affidavit of citizenship, which we talked about earlier. They may say, well, that affidavit is hearsay unless you take the witness stand. Yes, Your Honor, I'll take the witness stand for the limited purpose only of that affidavit. I will answer any question as it relates to that affidavit. I will not answer any other questions. The affidavit that says basically, I was born in Chicago, Illinois, on such and such a date. My parents were Illinois citizens, et cetera, et cetera, et cetera, establishing you were a state citizen. I'll be glad to answer those questions. You can't ask me anything else. But restrict them. You have to learn how to box them in. And your officer, when he's on the stand, you have to get him upset and get him nervous. Because we found a new way of doing it. As soon as the officer gets up on the stand and the prosecution is going to talk to him, then you're going to talk to him next. Then the first thing you're going to, out of your mouth before you ask him what his name is, or how long he's been in academy, the first thing you're going to say to him is, officer, you are under penalties of perjury right now. All I want from you is the truth. I do not want any lies. I don't want any guesses. I don't want any thoughts. I want the absolute truth from you. Remember, I know what the truth is, and if I catch you lying on the witness stand, I'm going to ask the judge to sanction you under penalties of perjury, and you may get 5 years in prison. Do you understand that, officer? And of course, the prosecution is going to immediately jump up and say, Your Honor, intimidating the witness. No, Your Honor, this is a hostile witness. And I'm invoking the hostile witness provisions, and I'm trying to enforce in this, officer, I only want the truth. I don't want lies. I don't want guesses. I want the absolute truth. If he knows it. If you don't know it, say so. That's all I'm asking, the absolute truth. Then you can go into your little scenario here. There's several pages of questions and answers to the thing there. We won't go over all those because I've got too many cites to go through and too many arguments to cover. Turn back to about 5, 6 pages to where it says speeding tickets. You can go through all those questions yourself at home and read them over. I've taken the time to enter these into the computer, and I think everybody should take time to read them at their leisure. Speeding tickets. We have not paid but one speeding ticket in California in 6 years. They can't prove you were speeding. It's impossible to prove you're speeding because they can't prove you violated the law. And in California, and in most states, they have speed traps are illegal. And a speed trap that's illegal, they have to prove their prima facie case. On a radar speeding ticket, they must bring in the radar calibration gun, the traffic survey showing that it's been completed within 5 years, and the calibration of the tuning fork. Then they always forget the calibration of tuning fork. And you got to check and make sure that it's done recently, because he may have dropped the tuning fork, which happens quite often. Motor officers are always dropping their tuning fork, you know. Knocks it out of whack. And always insist that they bring everything in and make sure that it's current, not one 3 years old, and make sure that it is a certified copy, because on the back of it, it should have a purple ink stamp on the back of it in California. That certifies that's an original. No Xerox copies permitted. Xerox copies are not permitted. And a speedometer, that's the best one of all to beat. We ask for everything but the kitchen sink. Go to the bottom of the page, it says speedometer. In order to establish the prima facie case in all speedometer speeding tickets, the officer is required to bring into court the following. He is required to bring them in voluntarily. You don't have to ask for them. They have to do everything voluntarily. They have to bring it in without you asking for it, because they have to prove their prima facie case. If they don't prove their prima facie case, they cannot convict. The speedometer calibration record for that specific police car by serial number. They may bring out a speedometer calibration record for 10 cars, and what car were you driving that day? I was driving 783. Okay, and 783 there. Do you have the trip sheet for that particular day showing that you were driving 783? Oh, you don't? Then there's no proof that you were driving that car. Is that what you're telling me? You don't have any evidence. That was the car you were driving. See, every officer, when he gets in the car in the morning, he writes a log number down. He makes a trip sheet that day where he makes all his calls and everything, puts the car number down, the mileage, and etc. Keeps track of everything. He's got to bring that into court. If you don't bring that into court, he can't prove he was driving that car. We don't know what car he was driving. See, then if he does bring all that in, then you go to the next phase. Then he's got to bring in the road engineering survey for that specific section of road, establishing that the traffic survey has been completed within 5 years. And if he brings that in, then you go to the next one. And he must voluntarily state that all the tires were properly inflated. And he has to establish by his trip ticket that the air pressure in every tire was checked by him, and it is the same air pressure on the date the speedometer was calibrated. He's got to bring in the air pressure. You know, when they calibrate the speedometer, they do it by the tires and spinning. And air pressure must be the same, and they must state how much the air pressure was in those tires. Because if they don't state what the air pressure is, then how do you know that it's accurate because 5 pounds of pressure in a tire will create a 3 to 5 mile variance. You don't want to give them any opportunity. Make them prove every single element. And he's got to prove it. Then if he brings that in, then you go to the next one, number 5, next page. Top. All transmission and speedometer repair records. If there are no speedometer and transmission repair records, he must so state. If he doesn't state, then he's in error. You're assuming, and there's no presumption allowed in a criminal trial. You're going to get those in court cases. If the officer forgets to bring any of those, you just stand up and say, Your Honor, I move to dismiss because the officer failed to prove his prima facie case. Write that down. Failed to prove his prima facie case. It's on there for you. You can underline it. It's very important. I had a Taiwanese guy who didn't speak very good English, and he got 2 speeding tickets in a row from LAPD in Van Nuys. It's 2 in a row, one day and one the next day. And he went in and did this argument, and in the first trial, the judge, 2 days apart, one day and the next day went to court. The first day the judge says he moved to dismiss for failure to prove the prima facie case, and the judge says, I can't accept that. He said, okay. So then he went on the next day and went before a different judge. And the judge told him on the second day, I believe the officer was correct in what he did. He said, but he failed to prove his prima facie case. He said, that's okay. He said, I believe the officer was correct in what he did. So he came to me and he said, what am I going to do? I said, it's very easy. File a notice to appeal that the officer failed to prove his prima facie case. That's all you're going to do on both cases. So he filed 2 notices of appeals. A week later, he gets a letter back from the appellate court saying that if he'll vacate his appeal, they'll reverse his conviction and refund his money back. They don't want the argument up there. They don't want the failure to prove a prima facie case argument up there. You can use it almost in any argument. You can always end with that. They don't like that. Now turn it over to the next page. These are objections. Pretrial motion to reconsider motions and briefs filed and argued. Discovery. Object to all evidence and witnesses not revealed in discovery. Most times the DA is too lazy to give you discovery. So if they don't reveal anything, they can't enter it into evidence. Okay? Object on the grounds of hearsay. There's no proof. Leading and suggestive. Ask and answered. You know what I mean? No proper foundation. There's a whole bunch of different ones you can use. Any different circumstances, okay? And on the next page, how to ask questions. Who did you see come out of the house? Who did you see in that automobile? Well, I saw you. Are you sure you saw me? Are you absolute 100% positive? As George Gay did in his case, walked up a blank piece of paper and says, also I have proof right here that I was not the person driving that motor vehicle. He's saying all the right words. He says, now are you positive? And judge and officer says, I think you were. So I think so. The judge dismissed. But you have to have intestinal fortitude. Don't be ashamed to get up and take positive action, because if you're going to back down and be a wimp about it, you just might as well pay your fine and keep right on going. You know what I mean? Pay the next one. Keep your billfold out, because you're going to be doing it quite a... Turn over to the next page. it says presumptions. Demand for judicial notice under the evidence code of the use of presumptions. This is very crucial. All your judicial notices should be predicated upon the same principle as this here. Notice is hereby given that on the blank day of 1995 at 13:30 hours, or as soon thereafter as the matter can be heard, blah, blah, blah. John C. Slave No More, that's my moniker I use, you know what I mean? If you ever see John C. Slave No More in any document floating around, you know it came from me. That's my alias. But the C, I've changed it now, is John Cecil Slave No More. I like the word Cecil. Makes me look like a dork. Because I is one. Presumptions are not allowed in all criminal trials. No presumptions are permitted in criminal proceedings. That's People v. Roeder, 1983, 33 Cal 3rd, 491. That's the California Supreme Court saying there's no presumptions allowed in any criminal trial. There are presumptions allowed in civil trial, but not in criminal. In criminal, there must be absolute positive. They can't presume anything. The prosecution must establish all underlying facts, elements essential to the accused's guilt, beyond a reasonable doubt. That's what the committee said on presumptions. The burden of proof is upon the prosecution to prove every single element of the alleged offense and not use presumptions in lieu of physical evidence. That's the Evidence Code 550. Okay? Thus, the prosecution, who has the burden of proof, is mandatorily required to physically produce all the evidence that would sustain a conviction whenever there is a possibility of loss of life, liberty, or property. Thus, the use of presumptions are extremely prejudicial to the accused in the instant case. And the judge in Santa Barbara accepted this judicial notice. Then you attach an order. Now turn over the next page. Anytime you're going against a district attorney, you always attach a court order to it. And you force the judge to sign this. Upon due cause and proper showing, the following order is made to the prosecuting attorney and their witnesses. It is hereby ordered that each and every element of the case must be proved with admissible evidence that no presumptions will be allowed. Judge says, I'm not going to sign that. Oh, Your Honor, you can allow presumption in this court case? I want it on record. Let the record reflect that the judge refuses to order the district attorney not to use presumptions. And just say, you're hamstringing them. You know what I mean? Now, it's one of these damned if you do and damned if you don't things. You know what I mean? Which side do you want to shoot himself? This blank here if he signs it, blank here if he don't sign it. But you have to know the argument to put him in that box. You keep putting the judge in a box. And there's several judicial notices with orders on. And Your Honor, there's a court order attached to that judicial notice. I'd like for you to sign it so the district attorney will be aware and we'll have a positive record in case I am convicted. That the...
Just on prior to the case?
Yeah, prior to the trial. Read the paperwork. It talks about it earlier. We talked about it earlier. Turn over the next one. There's another judicial notice. This is one of the most important ones of all. Demand for judicial notice under the evidence code of the use of prior judicial knowledge. Notice is hereby given that on blank day, etc., the heading, got my name there. Richard James, McDonald will move the court to enter this notice as evidence and take judicial notice of the ancient Talmudic maxim of law as espoused in the laws of the Talmud. Special notice is demanded of the following. And the Latin phrase there. It matters not what is known to the judge, if it is not known to him judicially. This maxim of the law is currently approved in U.S. v. Lewis, 833 Fed 2nd, 1380, 1987 court case. The court held that it is error for a judge to make conclusions based on his personal knowledge. That's what the court said. Can't use his personal knowledge. So how do you use that? Your Honor, Are you denying that judicial notice based on your personal knowledge? Yes, I am. Thank you, Your Honor.
Does that need an order to go with that one too?
No, not to the judge, only to the... There's no order when you do it to the judge, only when you do it to the district attorney. This one is to the judge. He can't sign an order to himself. And it goes on to say, also the maxim, no one is a competent witness whose knowledge is based upon hearsay and conjecture. The officer's sitting on a stand. Officer, do you know what a motor vehicle is? Are you positive? Or is that hearsay just what you've been told? You don't know for sure, is that correct? You only got a hearsay from the academy. So he's an incompetent witness. His witness is based... You don't have personal knowledge of what a motor vehicle is, do you? No. Do you have personal knowledge when you're asking the officer? You always ask the officer, do you have personal knowledge, blank, blank, blank? Do you have personal knowledge what a motor vehicle is? The prosecution can't object to that. But he say, you know what a motor vehicle is? Objection. But if you say, do you have personal knowledge? If he doesn't have personal knowledge, how can he figure out what a motor vehicle is to give you a citation? The court is requested not to utilize any prior acquired knowledge and to be completely neutral, fair and impartial in all respects, and to make his decision based upon the law and the evidence presented during trial. If there's no evidence presented in trial, he can't convict. He may, but he can't. But when you go up on appeal, there's no evidence in the trial record. Okay, next one here, go back 2 pages, is notice of motion and motion to return household goods mistakenly taken as equipment. We've gotten back 7 cars so far that I know of, probably a couple more that I don't know about. Other people have copies of this, and I don't hear about them. 8, I just heard about one in Indiana using it. The last one I heard was Bob down in San Bernardino County. They took his unlicensed truck out of his driveway. Out of his driveway. And he went into the watch commander and explained to him that this was household goods and it was not business equipment. It was private property. It was not a motor vehicle, this pickup truck. And gave him this argument here. And quiet. I'll get you after. Let me finish talking, okay? Because get me off point. And he went in and had his meeting the next day with the watch commander, or captain. The captain wrote him a letter and told him to go and drive his household goods out of the impound lot free of charge, no towing fee, and apologize for the sheriff's department. That just happened 2 weeks ago. Yes, now. It says autojud.note. And I'm not going to read the whole thing there for you, but that's what it is. And you should read the whole thing at your own, that the automobiles are household goods. They are not business equipment. See, the government can impound any piece of business equipment out there, but they cannot go in your house and take your refrigerator out of your house without a search warrant or a seizure warrant. And that means if your car is a household, classified as household goods, it can not be seized. But if you call it a motor vehicle or a vehicle, you just shot yourself in the head. You can't use that term. Wash it out of your mind. You just like washing your mind out of Title 26 out of your mind. You wash the term motor vehicle, vehicle, and driver out of your mind. You wash the term person out of your mind. Because those are nasty words, evil words. Because if you don't use those words, they can't move forward. Now turn over to the next one. I'm going to do a little computer and put it up here on the screen here. So I can talk, make it a little easier. Take a 2-minute pause here. I've got an old slow machine here. Of its agents or employees to properly respond to an affidavit. It's a 1993 court case. You have it in your book. How would you use this court case? Right down below it. You write it in a letter to the DMV when you cancel your Social Security, driver's license. You write to DMV when you to Social Security. You invoke estoppel if they don't respond, and you give them an affidavit saying I'm a state citizen, and they don't respond to that affidavit with another signed affidavit, not just a form letter. They have to respond properly to each one of them. Okay. Now here's another good one for you. No determination of status. That's the United States Supreme Court case, 441 U.S. 471. Nobody can make a status determination of you. Only you can do it. Only you can make a status determination. They can't make one for you. So you write them. If they send you a letter and say, oh, you're making a political status determination for me, and there's numerous court cites in this court case. And there's another one to the United States Supreme Court right here. There's an older one. Nobody can make a political status determination except you. And you have to tell them, you can't make a status determination. I'm making my own status determination. Only you can make it. I can make my own status determination. I can't make one for you. I can't make one for anybody in this room. Only you can make your own status determination. It's very important. Especially when you're writing to some of these nasty government agencies. You know what I mean? Tell them that this is your political status. You know what I mean? I like to use this one. Administrative jurisdiction means the power of an administrative tribunal to adjudicate legally, and the abuse of administrative discretion renders an administrative adjudication illegal. So you always ask for a DMV hearing. You get a ticket, you write and ask them for a DMV hearing. They're not going to give it to you. But you have to ask for it. Because now you have several different ways of fighting it. As soon as you got a ticket, you can ask for administrative hearing. I got all the court cases here for it. Or they refuse to give it to you. If they give it to you, you go and make them prove that you're involved with a commercial activity. Make them, the DMV, prove you're a person. Make the DMV do this. Make the DMV do that. They don't refuse to give it to you. You still want to mess with the DMV? Very simply. You do a writ of administrative mandamus against the DMV. And make them prove. Because they're the ones that authorize that cop to give you a ticket. You can do the same with any government agency. Make them go through the administrative procedures. Yes?
You're saying you use the Cites, the DMV, for instance, refuse to give you administrative hearing?
You're right.
And the result that your site is going to have.
They should grant you the administrative hearing. Then you do a writ of mandamus against them if they don't. Read tells your third, page 370. Tells you all about it right there. Here's a good one. The record must show affirmatively that the jurisdiction requirements have been satisfied. What are the jurisdictional requirements? In the IRS case, they must prove that they were legally authorized, they were established. There's a statute creating them. The DMV, they got to prove that the DMV was legally authorized to regulate me in a non-commercial activity. Make them prove every single element. Don't let them get away with anything. You're going to have a whole bunch of court cases that they have to prove. That's on the book, right there. I'm just going through the page by page. That's on page 2, I think. Down at the bottom of the page. Make them go. Make them prove everything. See? Jurisdiction is essential to give validity to the determinations of administrative agencies. And where jurisdictional requirements are not satisfied, the action of the agency is a nullity and may be attacked collaterally. You know what I mean? There's a whole bunch of court cases there. This one right here is very good. O'Neill versus Department of Professional Vocational Standards. This one here, when you read O'Neill, specifically states that if you do not have a license, they cannot cite you. Cannot be given a ticket. He was a contractor, okay? And the contracting board cited him in, you know. And he said, I don't have a license. You can't haul me in the court. And they said, right. You can't suspend his license because he don't have one. The same principle holds true with the DMV. But you've got to hold the feet to the fire. And if you start backing down, you're hurting, believe me. You don't want to back down. And you can file a whole bunch of motions to dismiss based on this one simple factor right here. A jurisdictional fact is one, the existence of which is a conditional precedent to the lawful exercise of administrative or judicial authority. Same thing, same principle. Motion to dismiss for lack of jurisdictional fact, i.e., I'm a state citizen, I'm not a U.S. citizen. Motion to dismiss for lack of jurisdictional fact, i.e., I was not involved in commercial activity. Motion to dismiss, you know what I mean? Whatever, you know what I mean? Lack of jurisdictional fact. Motion to dismiss that I had an automobile, not a motor vehicle. Lack of jurisdictional fact. That's the title of the document. That's why I give you samples of how to create a lot of these.
Hey, Richard,
Yeah.
would that be a motion to dismiss or a motion to abate? Since
Motion
jurisdiction
to
doesn't...
dismiss. Because you're in trial already when that comes about. Now here's a key one for you must understand. The plaintiff bears the burden of establishing jurisdiction. Let me repeat that. The plaintiff bears the burden of establishing jurisdiction. Here plaintiff presented no evidence to satisfy this burden, nor any evidence demonstrating that the burden was excused. A presumption without the necessary foundation cannot establish jurisdiction. That's on page...
You know what, everything was going in order until,
Yeah.
until you hit that one?
Until you hit that one.
And then all of a sudden we're lost. That page must be missing. Shoot, I'm looking, I don't see it. I'm back about 10 pages and I still don't see it.
Millrod. She's improving, yeah. They messed it up. Okay, well, write it down there. Just write this case down here, okay? Yeah, it makes... That's my printer. I didn't verify everything, you know what I mean? Most important thing is write this site down right
You know what,
here.
numerically, the bottom of your pages are in order.
Yeah, but I might have added some new stuff to it, too, as we go along. That's why I put extra stuff there. Milrot versus Stamper. 51 Cal Reporter 2nd, 424. 1996 court case. That's a new one. That's one I just added in last night. After the books were printed. It's a brand new one.
I can't read it.
Milrot, M-I-L-R-O-T versus Stamper. 51 Cal Reporter 2nd, 424. Just write the site down. You can just make a quick notation of what it is. That's one I dug out last night. A plaintiff bears the burden of establishing jurisdiction. Here the plaintiff presented no evidence to satisfy this burden, nor any evidence demonstrating that the burden was excused. A presumption without the necessary foundation cannot establish jurisdiction. The necessary foundation being, in an IRS case, is whether that IRS was lawfully created by an act of Congress, or that you were involved in a regulated activity. I think I put 6 new ones in here last night. Everybody got that?
Well, you can print these out for us and have them for us tomorrow.
This is on the bulletin board, right? All this stuff they...
Yes, it's about the program, yeah, you can have access to all this. Okay. See here, now here, this one here is right in there, see? Therefore, it is necessary, it should be the next site down there.
Good.
Yeah. Therefore, it is necessary for the record to present the facts establishing the jurisdiction of the tribunal. A whole bunch of court cases are saying the same thing. It's consistent. They're always consistent in their rules. They always tell you the truth. I don't care whether it's a 1802 case or a 1996 court case. They say the very same thing every single time. The principles of law remain the same. Okay? Therefore, it is necessary for the record to present the fact establishing jurisdiction of the tribunal. They've got to present the law and establish that they have authority to do what they're doing. If they don't, see, no administrative agency can act effectively where it lacks jurisdiction. The same way with the cop, the court, everything. It's all the same. Principle remains the same. If they don't have jurisdiction, they can't move forward. Make them prove they got jurisdiction. Make them prove that the IRS was lawfully created by an act of Congress. Make them prove that the DMV was lawfully created by an act of the legislature. Make them prove that the California Highway Patrol was created by an act of the Department of Housing and Transportation. Make them prove all these statutes in here. And a city police officer, make them bring the city charter in. Don't go on the presumptions. Don't assume that they are lawfully there because they're there. Make them prove it.
How does that fit in with the presentation that his name slips me did Saturday with the fact that none of the codes here in California...
Well, that's a totally different argument, but it's the same thing, same principle. Goes right along the same thing, totally different argument. Different. You're approaching a hill from a different standpoint, you know.
Like one line is missing on the quote there.
Should be on the next page. Okay, here's another one. Courts recognize the distinction between administrative action that is beyond the scope of its power or is a nullity in any event, and action that may be invalid because of defects growing out of the administrative process. Yeah, I see it right here. Jurisdiction, yeah.
Well, that's not that.
It doesn't matter. Because you can get Brenner versus Los Angeles and get the whole site. You know what I mean? That's my computer. That's me. The key issue on this particular case is, let me explain, that beyond the scope of power is a nullity in any event. That's what the issue, that key thing. This one here, an action that may be invalid because of defects growing out of the administrative process, is an admission that the administrative agency had jurisdiction. Making the legal distinction between one has administrative jurisdiction, one has no jurisdiction. The first one, that beyond the scope of is a nullity. You must understand. I don't know where I lost that word at. I didn't proofread the books to find out. There you go. Listen to this one. Congress is prohibited from making an investigation into the private affairs and papers of a citizen. Kilburn versus Thompson. It's a 1900 case, early 1900, prior to Social Security, prior to the Buck Act. All this changes after. Now they can do it because you're now a legal entity with Social Security. So once you become a citizen, you can use these. Right? And wait, I'm getting wired for sound now. See this? And write to them. They send you a letter and say, hey, we want you to bring in your tax records, and send them back a letter and say, hey, you don't have the right to ask for this information. You quote this, I'm a state citizen, I'm not a U.S. citizen. Then make them go into court and prove you are a slave. Make them prove every single element, which you must do. You've got to consistently prove. Remember we were talking earlier. For a certain purpose, California has passed challenging agencies' jurisdiction, said that ordinary mandamus is the route to take, called a non-CCC 1094.5 action. So if the agency, the DMV, if the DMV refuses and you do a mandamus on them, don't be ashamed. It's very simple. Got too much echo in here. Okay. And the Civil Code of Procedure section that you should be interested in. You can move forward all the way down the line. Okay?
You're not saying, and by citing the code, you're not saying that that code applies to you, you're saying
It applies to them. Right. Okay? In Mumma versus Glendale, 1969 court case, it says, among other things, the court held that a zoning administrator who failed to act within the prescribed time limit lost jurisdiction to act, and any later act exceeded his jurisdiction. Same way with a business license. Business license, people come out and you've been in business for 3 years, they didn't act within 3 years, they've lost jurisdiction. You write your DMV and say, I'm not involved in commercial activity, and they don't summons you in the court, and they have ample authority to summons you, give you a cease and desist order, and they don't do it within that proper time frame, they've lost jurisdiction in the court. You can move to dismiss based on this one issue alone. It's very, very simple. Lost jurisdiction to act. Prescribed time limit. You write them a letter, you give them 30 days. They don't act within 30 days, c'est la vie, estapao. It's very, very simple. Okay, now here's a good one in case you are granted a hearing by the DMV. In the Alward versus State Board of Chiropractic Examiners, the failure to give licensee proper notice and hearing. Agency failed to assign qualified hearing officer to preside at hearing. Are cases where the agent or agency acts outside their jurisdiction. You ask for a DMV hearing, and you want a neutral hearing officer from the arbitration board. That's $500 a day they get paid when they grant you the hearing. You ask for a neutral hearing officer. You don't want some DMV employee giving you a hearing, because who are they going to rule for? They're going to rule for themselves. You want a neutral.
Richard, if you went into, say they took your car and you went into the highway patrol who took your car, and the little highway patrol commander said you were having an administrative hearing behind his desk in his office, that would...
That's good enough, you know what I mean, because you got to do that to stop the fees. We do that all the time here. We get our cars back. You guys up in Visalia won't download the information, so I'm sorry, I can't help you.
They're tapping my line, they siphon it off before I can get it.
If we only got 100 and some odd pages to go through, I'm only on page 5. In United States versus Massey, 550 Feds 2nd 300, it was held that where a government official does not disclose the full reason for obtaining a statement or waiver from an individual, such statement or waiver is in violation of Miranda and cannot be used as evidence. Okay, you got a driver's license. And did they tell you that they were going to use it against you, establishing you're an alien for tax purposes? They can't bring it into the... Or your vehicle registration. Did they tell you that the state had an interest in it? Or your social security number was you're now security for the federal debt? They can't use it against you. Strike it. Thus, under these guidelines, a driver's license, social security number, social security bank records, bank is an agent of the government, cannot be used to establish that an individual is a statutory resident under the so-called 14th Amendment, or for any other purpose other than the singular purpose item was obtained. Here's another good one. Contractor that builds on his own land, not for purposes of resale, is exempt from requirements of Contractor Registration Act. So you have a right. You don't need code enforcement to come out and tell you that you need permission and a building permit to put a roof on your house, as long as you do it yourself. But if you contract it out, you follow me? Then you get a building permit. But as long as you do it yourself, there's not a word that he can say. You can have your family members get up there, your brother and your sister, and your mother and your father, and get the whole family member. This is a family thing.
What if your family's a contractor? It still counts.
That still counts. Yeah.
What if you are renting and you have permission from your landlord to make improvements to the property, so you don't actually own the land?
Well, the landlord's doing it, you're not. You're not. I'm renting. I'm not doing it. Listen, this key. This is a key one. If you really understand law, legislative body may delegate authority to administrative board to adopt and enforce reasonable rule for carrying into effect express purpose of ordinance, but may not adopt regulation that abridge, enlarge, or modify enabling statute. Aguirre versus Lee, 1993 court case. The key thing right here is may delegate authority. And if you go back into your DMV here, it'll show you that all others are exempt. It's still invalid. Like Tom Maxwell showed you at the meeting last month, it's still valid. Go read the initial enabling statute. How many people know what the enabling statute for the Internal Revenue Code is? Yes, there is. The Public Salary Tax Act of 1939. It's a Title 4, Section 111. They're not going to put in Title 26. They don't want you to know where the law is. So it's in Title 4, Section 111. They do have enabling act. So you never, under any circumstances, state Internal Revenue Code. You get your mouth washed off with soap.
Was that Title 4?
Section 111. You can download it off the bulletin board. Yes, part of it. Of course, I know they're siphoning the phone lines between here and there.
Come down here to a short circuit.
Here's a good one for you. If there's a positive duty to speak and party remains silent to his benefit and to the detriment of other parties, failure to speak constitutes fraud. Fraud may be established by showing concealment of material facts which one is bound to, under circumstances, to disclose. How would you use that? You'd use that on a letter to the Social Security Board, the DMV, the License Bureau. You write and ask them. I know in Ventura County it says business licenses are voluntary. It says right on the thing, this is a voluntary license. Right on their application form, it says this is a voluntary license. You ask them whether it's mandatory or voluntary. And you ask them. And it's the government's duty to respond to you to show you where you're wrong. And if they don't respond to you to show you where you're wrong, then it's fraud. Because then you're going to go ahead and move forward. I got a whole bunch of these types of court cases. Because this is what I'm going to use on when I get my ticket.
Still waiting.
Still waiting. This is what Tom Maxwell's doing. Declaratory relief may be combined with a mandamus action to obtain proper relief. Particularly, administrative remedies are inadequate or unavailable. See, that's what this whole principle that Tom Maxwell's going through. Here's this whole court case right here up for you, right here. And may also be coupled with a preliminary injunction, keep them from moving forward. Here, and now we're starting a new subject. We got off of DMV. Quasi-judicial acts. Quasi-judicial or acts judicial in nature, determining that the agency has jurisdiction, occur when an agency makes a final determination based on a record and contest before it, where jurisdiction is admitted, proved overtly, or subsilentio. It should be or right there. Name versus tabla. The procedure required by statute or case law to enforce supposed wrongs must be strictly followed. Where jurisdiction admitted or proved overtly or sub silentio. they do not prove jurisdiction. They invariably forget to prove jurisdiction. Why? It's very important that they don't prove jurisdiction, because it doesn't exist. And they do it for a reason, because they do it to raise revenue. And if you understand that to put the rocks out of your wheelbarrow into their wheelbarrow, you've got a whole new ball game. Jurisdiction, a quasi-judicial question, because jurisdiction existence depends solely on a court acting in a judicial capacity. Northern Pipeline, you know what I mean? If an administrative agency which has no judicial power determines that it has jurisdiction, that act of determination is in fact a matter of law and a judicial or quasi-judicial act. Revenue agencies are merely ministerial. Read that there. Revenue agencies are merely ministerial. Royal versus U.S., 312 U.S. 289. What is your DMV? That's a revenue agency. What is the FTB? Revenue agency.
Parking enforcement.
It's revenue agency. They're purely ministerial. So you can attack them from that aspect. See, and they're going to try. The court is not limited to the agency's record and may take evidence outside the record. That's you. You've got to bring in outside evidence establishing your through affidavits that you're not a U.S. citizen. The law also requires agencies vested with or exercising quasi-judicial power to make findings of fact. An agency is not allowed to proceed without them. So you write to DMV and you send back your driver's license. And they turn around and send to you, hey, they're going to come back and say certain things to you. What are they going to say? They're going to say, you cannot drive a motor vehicle in this state. That's what they're going to come back and say, which is lawfully correct. But then you write back to them and say, I'm not driving a motor vehicle. I'm using my automobile, which is non-commercial in nature. Are you making a determination that my automobile is a motor vehicle? They will not answer you because they can't make that determination. Only you can. And how do you make that determination your automobile is a motor vehicle? When you register it. Now it becomes a motor vehicle. See, you make the determination. You shoot yourself in the foot all the time. Here's a good one. I put this up there for a reason. It's very, very, I'm going to have a lot of fun with this eventually. It would be unconstitutional to require an individual to secure a broker's license before selling securities, which he has purchased and owned himself, as it would deprive him of his constitutional right to acquire, possess, and dispose of property. Key thing being, I have the right to possess and acquire property. My automobile is my property. Now they want me to secure a motor vehicle license and give away the ownership of that? That's unconstitutional right there, 1937. You see the different arguments that you can phrase out of each one of these different court cases. Here's a new one. I don't know whether this one's in your book or not. Substantive due process prohibits governmental interference with persons' fundamental rights to life, liberty, or property by unreasonable or arbitrary legislation. 1993. So you quote that back, quote this court case back to him and say, hey, Mr. DMV, you're interfering with my right to life, liberty, or property. Liberty is the right to work. And you write that to your local revenue agencies. You know what I mean? By arbitrary legislation. I'm not a legal entity.
You go buy a new car from a car dealer, how do you get them to turn that documentation over to you rather than sending it to DMV like they're in the habit of doing?
There's a certain way of doing it. You can't finance it. It has to be paid for in cash. Okay? Listen to this. The right to drive a motor vehicle on the public highways, is it not a fundamental right? So as to require strict scrutiny of any law which appears to classify driving privileges of persons otherwise similarly situated, and to necessitate a compelling state interest before such classification may be justified. The key phrases: drive a motor vehicle, right there. It tells you the whole thing. That's not a fundamental right. What is your fundamental right? The fundamental right is to use your automobile for personal, private pleasure. That is a fundamental right. See, they always use the key words when they do these court cases, so you have to understand what these key words. And if I'm successful in teaching you how to look at these key words to answer these questions, in 2 days I think we're going to do real well.
The word drive is a key word.
All right.
Yes. Use.
Enjoying your right of way is the way to go. I just enjoy my right on the right of way.
See here, there's a constitutional right to intra-state travel. That's what I do. Constitutional right to interstate travel. I do have the right to interstate travel. That's all I'm doing. I'm traveling. I'm not driving.
How is that effective then once you cross the state line?
Then there's another federal court case that says the same thing. There's a whole bunch of them. Exemption of operators transporting persons to and from public schools, persons transporting their own property or employees, and those not transporting for hire from motor vehicle license tax was valid. That's a 1926 court case. See, these are the court cases that Maxwell's using right here. Schmolke, Bacon, you know what I mean? Key thing there, transporting their own property or employees, not trying to promote, was valid, okay? Motor vehicle license tax was valid because it only involves commercial activity. And this goes all the way back to in Ray Stork case in 1914. Goes right back to the same thing. This is quote the statute. Yeah. Here's another one. Exemption of vehicles operated within city limits from motor vehicle license tax was valid. In Ray Schmolke again. Oops. I hit it too hard. There's another.
We got the same problem on our page.
Yeah, okay.
Next one, unless there's something for us.
Yeah.
Agency rule is arbitrary and capricious.
Right. Agency rule is arbitrary and capricious if agency has entirely failed to consider an important aspect or problem, or offer explanation for its decision that runs counter to the evidence before the agency. You attack them that the agency rule is arbitrary and capricious The important aspect of problem is what? Your state citizenship. You're not involved in the commercial activity. Those are the important aspects. And it's Crowley's Yacht, the 1994 court case. The DMV, if the court fails to utilize this important aspect, you can bring it up to court. Anything here goes for agency or courts. They're all ministerial in nature. They apply both ways. Here's another one. Abuse of discretion may be found where agency fails to consider all relevant evidence submitted. Your Honor, are you refusing to take into consideration my affidavit of state citizen? My affidavit that I was not involved with commercial activity and I was not involved in any federal area and I was not a U.S. citizen. Are you refusing to take that into consideration while I'm rendering your decision? You see how it's important? There's numerous court cases along these same lines. I just don't give you one, I give you several. So here's a good one I like. There's another typo. I didn't even spell check it. I was hurrying to try to get it out. Litigant must preserve and must not alter documents it knows reasonably would prejudice opponent. You send a letter to the DMV or to any three-letter government agency, you know what I mean? And you summons them in to bring it in, you know what I mean? Your allegations that you're a state citizen. And if they don't bring it in, you're prejudiced by it because that proves your intent. That's a 1994 court case. You'll find a lot of new court cases, old court cases, they're all the same thing. Remember we talked about demurs earlier. I'm going to have to speed up here a little bit. Demurs. To sustain demur for want of jurisdiction, the defect must appear on the face of the accusatory pleading. What is the defect on every ticket? No, they check the traffic box. That's the key thing that is defect. And number one, they call you a driver. That's another defect. And another one, it says vehicle license plate number. You know what I mean? That's a defect because you don't have a vehicle. You follow me? That's an assumption. That's a presumption. I think on the ticket I counted 11 different presumptions that are on each citation. But you have to challenge each and every one of them. And we always go in on a non-statutory demur. Most people say there's no such thing as a non-statutory demur. Don't argue with me, argue with the court, 1985. The erroneous overruling of a non-statutory demur by a trial court is possible and can result in reversal of the judgment of conviction on appeal. Thus, a non-statutory common law demur exists as a vehicle for constitutional and other attacks on the sufficiency of an accusatory pleading. You don't have to use their code. You can use the common law. This is what it's telling you. Courts recognize it. There's two. How many people know there's two writs of habeas corpus? One for state citizens and one for U.S. citizens. There's two. Two in federal court and two in state court. There's two of them. One's statutory and one's constitutional. There's two of everything. See, and if they overrule your demur on a for judgment of the dismissal, sustaining of demur without leave to amend, appellant has burden to show either demur was sustained erroneously or that to sustain demur without leave to amend constitutes an abuse of discretion. I always recommend abuse of discretion. The courts always will look on at abuse of discretion rather than some of the other charges. That's a 1993 court case, if you notice. We're going to skip the next couple there because that's out of a law book, just for your information. Talks about demurs there. That's a book out of Common Law Pleading Hornbook Series, 1923, Benjamin Shipman. That's another one out of Benjamin Shipman. Yeah, and you can buy it at most law schools have it. A lot of these demurs we can skip over. Here's a good one. We skipped down about three, 4 pages. On objection that complaint does not state cause of action raised for the first time on appeal, pleading will be liberally construed, and if necessary, facts appear even by implication or a conclusion of law, judgment based on complaint will be upheld. See the key thing right there? First time. You have to raise it at the trial level. Your failure to raise the issue by demur waives it. Waives that argument. You can't bring it up on appeal. You must always. What this is telling you, what tells me, is that if you issue not raised at the trial level is waived. That's basically what it's telling you here. So you must bring everything up at the trial level. Failure to bring it up at the trial level is bad.
What about jurisdiction
and the... We're talking about the complaint. I'm not talking about jurisdiction. Anytime, but I'm talking about the complaint. Where a complaint is first attacked on appeal as not stating facts sufficient to constitute a cause of action will then be liberally construed. Same thing again. Yeah. See? A pleading is to be construed most strongly against the pleader, at least when they are sworn to. So when you file a pleading and you put an affidavit with it, it's got to be very strong, because it's going to be liberally construed for the other party. So you have to tailor it very narrow. You tailor your arguments very narrow. Don't put all your eggs in one basket. Because if you put all your eggs in one basket, you're going to... See? Pleadings and abatements should be strictly construed. That's correct. Because the pleading and abatement says, hey, there's no crime. A pleading and abatement is totally saying, hey, there's no contract. We do non-assumption, no contract. Now they have to narrowly look at it and see, hey, well, there is a contract. And you make an affidavit that there is no contract. Here's a good one. If a pleading misstates the effect and purpose of the statute upon which party relies, a demur to the pleading does not admit the correctness of the construction, or that the statute imposes the alleged obligation or confers alleged rights. Notice I put it in red right there. That's for my notes. See what I mean? For my computer. No, read this case. Penny versus Reese. And you also, there's two types of demurs. There's a general demur and a special demur. Specification must be made of grounds on which a complaint is subject to a special demur. You can have 5 special demurs demurring to each specific item, where a general demur attacks the whole thing. See, a special demur.
Because it said up front you're only allowed 1 demur, but you can have 5 special ones.
Right. 1 general. Defendant desiring more specific pleading or more information should demur specially or demand a bill of particulars. Either way of the two. I always like to save my demur and use the bill of particulars. You know what I mean? And make them prove every single thing. You know what I mean? Make them define the words. Help them define the words against them. We're only 21. I ain't never going to get finished in 2 days. A pleading is to be construed most strongly against the pleader, at least when they are sworn to. There's another one. Here. You can file a special demur for uncertainty. Right here. Demur for uncertainty lies for what is said with uncertain meaning and not for what is omitted. Vague and ambiguous. Vehicle is vague and ambiguous, that has uncertain meanings. Driver has uncertain meanings. Everything has uncertain meanings. They didn't omit anything, it just has uncertain meanings.
You use the term vague and what?
Ambiguous. So we're on page 22, going on page 23, the bottom of page 22. The defendant may demur an answer at the same time to the entire complaint and also to each cause of action stated therein. So you can demur and then file your motion to dismiss at the same time. Makes no difference. That's your answer. Motion to dismiss. File a demur, then file a notice to abate. For 2 or 3, non-assumption, several different notices to abate. And then you turn around and file a whole bunch of motions to dismiss. Then file a whole bunch of judicial notices. And when you file your judicial notices, let's take a breather here and we'll talk about judicial notices. That's the first thing you address when you go into court. You file a whole bunch of paperwork. You walk into court and you say, Your Honor, there are several housekeeping chores we must take care of. They are the judicial notice. Let's do the judicial notice so we can set the playpen fence. So you can set the boundary lines.
You got before the demur.
Even before the demur.
As soon as you get something going.
You're right. As soon as you get something going, you do the judicial notice. You set the boundary lines. If you don't set the boundary lines, they're going to go way all over the place. But if you make them set the boundary lines first, they can only stay within that playpen that you set, those guidelines. You'll file them before. Read the first page. 10 to 15 days. Here's a good one that it's still principle of law today. An issue of law and fact should not be mixed in an answer. A demur should be filed as a separate pleading. See? The issue of law is the demur and fact. Demur only addresses the issue of law. We got a lot of demur. I'm gonna skip. Huh? A demur only attacks the law. Does not attack the facts. Facts is jury trial. Let's see. I've got a bunch of demur. I'm trying to skip them so we can save some time here. You can read a lot of these at home, you know what I mean? See what page we're on. Complaint, there we go. 28, complaint.
Possible we can take a restroom break?
Yeah, okay, let's take a quick break here. I'm glad you mentioned it because I'll talk right on through lunch. I've done that several times. I forget to take breaks. Section says complaint. Where a statute requires a court or tribunal to exercise its jurisdiction in a particular manner or subject to certain limitations and to follow certain procedures, any act beyond those limitations is in excess of its jurisdiction. That's the Los Angeles County versus Surrey. So a court, in order to acquire jurisdiction, since all courts are nisi prius courts, we had the judge in Santa Barbara accept the nisi prius argument. He said, yes, this is the nisi prius court under rule nisi. And he told the judge, the prosecuting attorney, you know what you have to do under rule nisi. So rule nisi is a contract court. And the judge up there in Muni Court admitted that all municipal courts are contract courts. NISIPRIUS. You can download it off the BBS. I have that. I ain't not gonna.
I knew what it meant. I just didn't know how to spell it.
Maybe for Christmas your wife might buy you a modem.
Yeah, and then she'll try to send me down it.
It says, the magistrate generally states that the mere notice to appear constitutes a complaint. But section 40513A clearly states that a notice may be only used as a complaint with permission of the person pleading guilty. Any plea of not guilty demands the filing of a verified complaint by a prosecutor. As a person issuing the notice is merely a witness for the prosecutor and not even a prosecutor, and even a prosecutor must have a verified complaint provided by the witness. So, as in the traffic case up in Santa Barbara, he asked the officer, did you verify this complaint? He says, no. He says, I don't know what a verified complaint is. Right on the witness stand. If he don't know what a verified complaint is, he didn't verify it, they're unable to accept the plea. And the court case that goes along this is Vehicle Code Section 40513 demands that a verified complaint must be filed in accordance with the Penal Code, Section 1427, before a court has jurisdiction of the subject matter. We have several different motions on 40513, lack of verified complaint. Yes.
Doesn't that penal code section also say that the verified complaint must be filed on the day the citation is written?
No, I think you got 10 days, 20 days. There's 20 days to file a verified complaint.
So if you're
Issue.
30 days after the...
No, they have 20 days to file after the citation is issued.
But if the arraignment is 30 days after that, then they've already...
Yeah. In People versus Wheeler, this California, a court ruled in reverse the defendant appeals from his conviction that the trial court lacks jurisdiction of the case. We agree. Under section 40513A, a notice to appear constitutes a complaint to which a defendant may plead guilty. Once a defendant pleads other than guilty, a verified complaint must be filed. In the instant case, no complaint was filed against him. Hence, the court was without jurisdiction. The failure to file a verified, The failure to file a verified complaint in the case did not merely result in a technical defect. It deprived the court of its power to act. That goes to original jurisdiction of the court. That's a foundational argument.
Richard?
Yes.
This site seems to suggest that the defendant would plead first and then demand the verified complaint. It should be the other way
We're
around.
right. Demand a verified complaint.
It's been filed. How do you know the complaint has been filed?
They'll hand you one.
Okay.
They'll hand you one.
When do they hand you that?
They should hand you that at the arraignment.
If they don't,
It's not that you demand a complaint, it's that they have to do it.
They have to do it. It's their duty. And failure to do it, see, you have to hold their feet to the fire. That's what these court cases are all about. Showing you what the court said in a specific instance. Showing you how to hold their feet to the fire. Or if the court says, hey, I'm not going to go along with Ralph versus police court. Oh, Your Honor, you're a Muni court and this is California Supreme Court. Are you going to overturn the California Supreme Court?
I was in a case where the judge told me you didn't ask for a verified complaint. Now, it's not my duty to ask for it, is it?
No, it may. It says may. In Ralph versus Police Court in 1948, it was held that a defendant cited for and charged with violating a vehicle who pleads not guilty is not brought within the jurisdiction of the court until a verified complaint charging him with the offense in question has been filed. That answers your question right there.
Now that could be challenged in the appeals too, huh?
Yeah. A universal principle is old as the law is that a proceeding of a court without jurisdiction are nullity, and its judgment therein without effect either on person or property. There's one back in 1918, about 1870, and the other one about 1910.
Richard?
Yeah.
You can't demur the complaint until it's been filed either, can you?
No, you can demur it to the ticket, citation. Jurisdiction is a fundamental, and a judgment rendered by a court that does not have jurisdiction to hear is void ab initio. See, there's always consistent. Always go to your foundational arguments. Don't go to the secondary arguments. Now here's a new case. I don't know whether it's in your book or not.
Yes, it is.
California Constitution is independent force, and rights defined therein are not mirror images of their federal counterparts. What is that saying? Your California Constitution is superior to the federal Constitution. You more have absolute rights under the federal Constitution. I mean under the state Constitution. Under the federal Constitution, you only have statutorily granted privileges through acts of Congress or other things along those lines. So your rights under the Constitution, state Constitution, is broader. The rights under your U.S. Constitution is very narrow. What do you want, broad rights or narrow rights? What do you want, to be a state citizen or a slave? Your choice in the matter. No, you don't. You don't have any. Listen what the court said in 1921. Encroachments on the liberty of the citizen cannot be tolerated, even though the general result sought is a beneficent one. 1921. And if you notice the key words, citizen. So they know exactly what they're saying when they write these. You follow me? Encroachment on the liberty of a person can be tolerated. You know what I mean? Citizen cannot be tolerated. Now we're going into the definition of malicious prosecution. Yes.
Can we presume that you jeopardized all these cases that you got?
Yep, they're all good. Yeah. Unless they got overturned just real recently. You know what I mean? Before we go on to this malicious prosecution, I'm going to tell you a few things. Under malicious prosecution, you can file a cross complaint immediately upon getting a citation. And write these three things down that you can file against the Department of Motor Vehicles, the police officer, everybody involved. You got a fan going on.
Yeah, he's trying to get it turned off.
Yeah. One is the RICO Act. You can file RICO charges against the police officer and the city department and cross complaint. And the cross complaints have to be heard first. Write that down. Cross complaints must be heard first. So if you know how to file a cross complaint, you file a cross complaint against the officer and the department and the DMV, charging them with RICO conspiracy to deprive you of your life, liberty, and property. And you charge the officer with malicious prosecution because you told him right up front you don't have a motor vehicle, you have an automobile, and now that's, when he issued that citation, that's malicious prosecution. And the officer is without immunity. Immunity not extending to officer who maliciously and without cause initiates prosecution against citizens. In Darius's case, it'd be the same thing. The officer said right on the witness stand, he says, you stopped me out of mere curiosity, didn't you? He said, yes. And then the next words out of his mouth, he says, I made a mistake issuing the ticket too. Voluntarily stated that on the witness stand. That's going to be a good one.
You said there were three things that you file right away. The
RICO Act, malicious prosecution, and there's actually about 10. One is violation of your rights to liberty. Then you can bring, under your liberty, you can bring your travel, your right to earn money, and etc. because he deprived you of the ability to work, you know what I mean? Because you had to go to court, and etc. You know what I mean? Earn a living. There's a whole bunch of different things you can do. Yes?
Is it really good to bring up any of these ideas with the officer when he stops you?
No. You bring them all up in court. Unless you want curbside justice. You know what curbside justice is? Night clubbing with LAPD. Open your mouth and you get nightclub. I don't recommend it. Malice and want of probable cause are the gist of action for malicious prosecution. Want of probable cause. I told you I had an automobile, not a motor vehicle. And he went ahead anyway. And without allegation and proof of both, action will fail. So you got to prove that. 1955 court case. Malice is capable of being inferred from lack of good faith of the accuser. When I told him what it was, he didn't believe me, so that's lack of good faith. Here's a stop. You can set the officer up at the stop. We're going to get to that tomorrow, but I'll be jumping around. Stopping of a vehicle and detention of the occupants constitutes seizure within the meaning of the Fourth Amendment. As soon as those red lights come on, he has to show that he has probable cause to stop you. And you can stop that. I'm going to explain how today, and I'm going to explain how tomorrow. I'm going to reinforce it. As soon as the officer stops you and you have no plates on your car, then he says, let me see your driver's license and your vehicle registration. He's going to say, you say, officer, did you stop me because you're curious because they didn't have plates on the car? He's going to say, yeah. Thank you.
Need to be recording that.
No, then you ask him that on the witness stand. And he stopped you out of mere curiosity because you didn't have plates. And that's illegal. We got a court case on that. September 1996. We'll get that tomorrow. So, in other words, they got to have probable cause to stop you. And having no plates is insufficient reason to stop you. Search occurs when state intrudes upon individual's right to privacy. Okay? This can be used several different ways. One, you can cross-complaint the officer for violation of your right to privacy in that you are tooling down the highway in your automobile and you have a reasonable expectation of privacy because nobody can look in your car. Now, when he stops you and he walks up to your car, as soon as he looks in your car, he's violated your right to privacy because you had a reasonable expectation, you did not violate any laws.
Can I make a comment right there?
Yeah.
Whenever you go through these border checks, those guys deliberately will walk around and look inside your car and stuff without even asking you anything.
But that's a different type of thing. That's not a red light pulling up behind you. You don't have a reasonable expectation of privacy at a border checkpoint.
Even though it's within the state. Not at
You have no reasonable expectation because it's a voluntary stop.
Could you say again what this state versus Gabbard?
Huh?
Could you say again what this state versus Gabbard does for you, how you can use that again?
No.
Search occurs when state intrudes upon individual rights to privacy.
You cross-complaint on the violation of right to privacy. And you use the state constitution. State constitutional right of privacy provides protection that is distinct from some respects greater than provided by the United States Constitution. So what do you want? A real narrow one? Use the U.S. Constitution like good little U.S. slave. Or if you want a broad one that covers everything, use the state constitution. They're consistent here. They're absolutely consistent. And here's one you walk them into. The Fourth Amendment prohibits stopping of a vehicle even for limited purpose of questioning its occupant, unless the police officer has a founded suspicion of criminal conduct. And not having license plates is not criminal conduct. That's curiosity. You haven't done anything wrong, you haven't violated any laws. And you can ask, officer, did I violate any laws? No. So you stopped me out of mere curiosity because I didn't have plates on the car. Yes. Thank you. You just go on to the next thing.
Richard, coming back to the search of vehicles, I found that in some research I was doing earlier this year that the police in California now are relying on a decision out of one of the appellate courts that they have reasonable cause to search your vehicle if you are in the vehicle itself for two reasons. One, the vehicle can be used as a weapon, or you could take off with it because it's in your control. And two, you could have a weapon within your reach, and which would...
But see, you're talking about something totally different. I'm talking about the right of privacy. Yes, I'm arguing that, and you're talking about that over there, Jim.
No, I'm not. What I'm telling you is that their expectation of privacy is overruled by this compelling state interest.
No, the United States Supreme Court says it doesn't.
Well, I understand, but what I recommend to my clients is get out of the car.
No, yeah, I would get out of the car too. But as long as I'm moving down the road, I have a reasonable expectation of privacy. As soon as he stops me, then now when he looks in that car, he has violated my reasonable expectation of privacy by merely stopping me. Okay? Just to stop alone, not looking in the car. Stopping me has violated my reasonable expectation of privacy.
Well, what if the officer demands you get back in your car? He says, don't exit your car. Don't exit your car. You know,
Well, then I'll stay in there.
And I had that happen to me, and I refused because I was not going to give him probable cause to search my vehicle. And he backed off right now.
Okay? Founded suspicion must exist at the time officer initiates a stop. See? He's got to have suspicion something's wrong before he turns those lights on. They don't. They're merely out there flipping lights on to make revenue. Founded suspicion. Oh, she's pretty. Maybe she's single. That's my founded suspicion. Or there's an old geezer. Looks like he's a doper. That's my founded suspicion. You know what I mean? Or there's a guy. He's too ugly. You know what I mean? he shouldn't be on the highway. We can cite him for being ugly in public. You know what I mean? There's a whole bunch.
And getting a profile is not sufficient suspicion?
Right. Yes.
At one time, Richard, you said that when you got out of the car, you automatically gave a police officer jurisdiction. Is that still true?
No. When I get out of the car, first thing I do is go like this. I say, officer, I'm no threat to you. I'm unarmed. And that relaxes him right there. In evaluating whether founded suspicion exists, the totality of circumstances should be considered. There's two court cases saying the same thing. One, the United States Supreme Court. And not having a license plate is not sufficient reason. Here's another one. Founded suspicion exists when officers are aware of specific articulable facts that, together with rational inferences drawn from them, reasonable warrant a suspicion that the person to be detained has committed or is about to commit a crime. And you ask the officer, did I violate any laws? No. So you've lost the reasonable suspicion. You've always founded suspicion. You overturn that, shut that argument down right off the bat. Where investigative stop or detention is predicated on circumstance which, viewed objectively, support mere curiosity, rumor, or hunch, stop is unlawful, even though officer may have been acting in good faith. Key thing, curiosity. Rumor. Officer, did you see my bumper sticker on the back of my car showing state citizenship? Yeah, he says, I know all you state citizens don't have driver's license. Oh, that's a rumor that's floating around the police department. Is that what you're saying? Yeah, thank you. Now you want to go to the next one, hunch. Oh, then you had a hunch about that too, that I didn't have a driver's license. Yeah, yes.
What if the police officer states that he pulled you over for not having a plate because he suspected that you were driving a stolen car? This is criminal conduct.
No. Then you say, officer, do you have a report of one of these 1972 white BMWs covered with rust spots being stolen recently?
Probable cause.
Huh?
All he needs is probable cause.
No, just stop it. Then you have to stop every car on the road that doesn't have plates in order to get around that. Do you stop every car you see without plates because it may be stolen? No, I don't. Thank you, officer. Oh, so you just selectively picked me out of the... Selective prosecution is a no-no. You see how you get around? Mere curiosity. And that's an old court case of September 1996. I think that's almost expired.
Yeah, that's a pretty old one.
Yes, brand new. The U.S. Supreme Court has defined and limited investigative detention. Any restraint of a person for the purpose of checking identification and asking questions or detaining him or her briefly while obtaining such as a detention. It comported with the form only when based upon articulable facts supporting a reasonable suspicion that the person has committed a criminal offense. The mere presence with someone who has an outstanding warrant is not sufficient. So in other words, you have to have reasonable suspicion against you. When police officers, with or without arresting an individual, detain the individual for the purpose of requiring him to identify himself, they perform a seizure of the person subject to the requirements of the Fourth Amendment. That the defendant's conviction requiring identification upon a lawful stop was improper. The police officer stopping the defendant and requiring him to identify himself violated the defendant's First, Fourth, and Fifth Amendments, was in violation of the United States Constitution. When police officer has no reasonable suspicion to believe that the defendant was engaged or had been engaged in criminal conduct. That's Brown versus Texas, 1979. That answer your question there, Shannon? Don't serve me. I'm younger than you are. You only serve your elders.
If they stop you, and, let's say you do what you suggested, officer, are you conducting a criminal investigation? Yes.
So then you just go right on and give whatever you want. Because once he says he's conducting a criminal investigation, he must, by law, read you your Miranda rights. And he's not going to do it.
Well, I was looking at it from a different angle. If he were to say, am I under arrest?
No, he's going to get touchy, sensitive. Are you conducting criminal investigation? Yeah, okay. Do it easily. Don't be, rub salt in the wounds, okay? You rub salt in the wounds when he's on the witness stand. Now here's another one. A person driving an automobile cannot be stopped to see if he or she is licensed to drive. They can't stop you, just a mere check. See if you got a license. See, this is Supreme Court ruling against roving stocks in Alameda Sanchez, which stated that the court rejects the argument that driving is a persuasively regulated activity subjecting motorists to roving stops. Court explains that a roving stop of a motorist was unreasonable. Driver was not in the same position as the gun manufacturer or liquor distributor who had in effect consented to an inspection by entering a heavily regulated industry. Officer outside his jurisdiction believing probable cause for arrest existed. Such circumstance was the same as that of a private citizen arrest. See, and a private citizen makes an arrest when the officer has been suable. If you can prove that he didn't have probable cause.
Richard?
Yes.
Is that to say, for example, that an officer with the Los Angeles Police Department who is, finds himself, say, in West Hollywood, is outside his jurisdiction because the city of West Hollywood is not the city of Los Angeles?
No, they have inter-branch transfers. They authority. Like in San Fernando, they signed a compact with the city of L.A. and the L.A. County Sheriff, so they all intermingle.
So then how do you know how far a given officer's jurisdiction extends?
When he's acting within the scope of his duties.
Suppose he's off duty.
Then he can only stop for a felony committed in his presence.
Or
Misdemeanor.
or citizen arrest.
If he does, then he's acting as a citizen.
Richard, have you got time to explain the difference between a public offense and a crime?
A crime, an infraction is not a crime. A public offense is spitting on the sidewalk, which is a mere infraction. Where a peace officer acting as a private citizen was authorized to commit a public offense in his presence, the seizure was legal. The officer was off duty. Now he's acting as a private citizen. Remember, under the Vehicle Code, a person within the jurisdiction of the DMV has agreed that certain violations of the code would carry penal penalties. That's 17459 and 17460 of the Vehicle Code. Those two sections. 17459 and 17460 of the Vehicle Code. That gives the state power of attorney. You agree to the service of summons.
That was 174.
59 and 60. Next one. Defendant makes a prima facie case of unlawful arrest when he established that arrest was made without a warrant and burden rests on persecution to show proper justification. You notice I said persecution, not prosecution. To show proper justification. So if they arrest you, you know what I mean? All you have to prove that the stop was an arrest, then the rest is downhill. And it's a hard road to hoe. on that. Yes.
For an arrest, they would actually take you in at that time, is that correct?
No, it's stopping you as an arrest if you study the word arrest. If you win all the court cases, there's about 40 of them that show you the different avenues. Mere stopping you, asking you for identification is an arrest. Personal liberty is a fundamental interest second only to life itself, protected by the California United States Constitution.